At times, you will want to use associates, students, or employees to assist you in the collection or analysis of information. Even though your attorney may offer the use of paralegals or other employees of his law firm, you should hesitate to accept those offers. If you have your own personnel, using them will enable you to oversee what they are doing and testify to the reliability of their work. This bears on yet another Daubert-related consideration. Using your own personnel enables you to legitimately testify to your assistant's work as being routinely relied upon in your particular field. You will need to be as organized in your collection of information as you are meticulous in your study of it. You should act this way because an expert witness has to offer more than just a valid opinion. You must be able to explain and defend the steps you took to reach that opinion. When you eventually write your expert report, in which you present your opinions, you will include in that report details of what you did, how you did it, and when you did it. Depending on your case and your investigations, you should always attend meetings with a notebook, pen, clipboard, recorder, and/or camera. These will be helpful for taking notes and for making records of what you saw and precisely where and when. You should also consider bringing miscellaneous other equipment that in your field may be useful, such as magnifying glasses, flashlights, binoculars, testing devices. Use these items to help you make records of people, machines, context, and whatever else is pertinent to your opinions in the matter. An important tactic to keep in mind is that you should not rely solely on your own memory, whether it's of interviews or site visits. Documenting your interviews and site visits will bolster your own memory. First, an opinion requires reference to facts, measurements, or other data to be acceptable. During testimony, you must precisely identify the details of how and when you acquired information. Those might include dates, locations, names, or simply procedures followed. You should document what you saw, heard, or discovered. Second, you can use those notes and observations to later jog your memory during subsequent analysis and study, and they also may guide you to further discovery and further explorations. You will have to refer to documents that you read by identification number and date, and you will have to refer to the names of people you meet and interview by name and date. By the way, when you do meet people and interview them for information, ask them how they spell their name so that you can include it correctly in any report that you write. Also, it can help to leave your business card with whomever you meet and interview. Suggest that they contact you if they think of any other relevant information that did not come up in your discussions. Offering people a convenient way to contact you in this fashion may result later in additional information. They may not have had access to that information at the time you met with them. Additionally, they may later remember important information that they did not even think of when you were there. The goal of your research and analyses is to logically collect information that is relevant to the case. As you progress in this collection of relevant data, you will begin to see a picture form. You will see what information relates to a particular scenario or element of the case. You will start to see how to group the materials you collect or the results of tests that you run. If you like to organize information in files, then do so. Organize your notes or the documents or the materials you collect into those files. Each of those groupings may then lead to a single opinion that you include in your eventual report and testimony. You can then refer to the documents as you write and build the foundation for each opinion. Finalizing opinions becomes easier if you have organized your materials such that you can readily find the information that supports each opinion. In most cases, the only written requirement will be your expert report. Whatever you record in writing or electronic form becomes discoverable by the other side in the case. This includes any emails you may write to your attorney. Think twice about putting information into email just because it's convenient, or because you can't reach the attorney on the telephone. That will happen often. Think twice about any documentation of your interim analyses, progress, or considerations. These written materials are potential evidence that may be difficult to explain, or difficult to recall why you even wrote them. Worse still, these writings may prove embarrassing to you if they suggest conflicts with your final opinions. As a tactic, then, use the telephone, not email, to keep your attorney up to date on your work. By the way, do not even consider deleting any emails or throwing away documented notes in your file. By law, you cannot blatantly destroy potential evidence. Laws concerning spoliation and obstruction of justice will govern your removal of written material from your file. This also includes misguided emails that your own attorney may send you, including revelations about the case or the attorney's tactics and strategies regarding the case.